last study. Start. In these circumstances, it is imperative that adequate provisions should be made in this behalf for hearing and redressal of the grievances etc. of the persons who are required to pay the fees. Stop para. Section 17 of the Act gives the power to levy and collect, which also includes the assessment. Stop. The explanation of Section 17 provides that the price of such produce presumed to be sold shall be deemed to be such reasonable price as may be ascertained in the manner prescribed. Stop. The proviso of Rule 66A says that when the specified agricultural produce is presumed to have been sold in accordance with the explanation given under clause 8 of section 17 of the Uttar Pradesh Krishi Utpadan Mandi Adhiniyam 1964, the price of such produce shall be the price which prevailed for that type of produce in that market just on the previous working day. Stop. Therefore, the mandi fee was payable on the price of such produce which prevailed in that market just on the previous working day. Stop. In case if it is found that the mandi fee has not been paid on the price which was prevailed in the market just on the previous working day, the committee has authority to issue notice and pass assessment order and raise the demand. Stop. Such order may be considered as a provisional order in view of the division bench decision of this court. Stop. If the licensee accepts the order, the mandi fee shall be deposited, and in case if he disputes the same, then it has a right to file the objection, and then on a consideration of the said objection, the final assessment order is to be passed. Stop para. It is true that at the time of transactions, when the gate passes are being issued on the payment of mandi fee in the presence of the inspector. Stop. It would be more reasonable that the objection can be raised about the rate and the market price, on the basis of which the assessment may take place subsequently. Stop. It is not necessary that at the time of objection the gate pass may be denied on this ground. Stop. In the present case, it appears that no objection has been raised at the time of transactions by the inspector who was present at the time of transactions, and mandi fee has been paid on the price mentioned in 6R, but in my view, mere not raising the objection will not preclude the committee to raise the objection subsequently on the basis of the material on record. Stop. Although it would be more appropriate that the objection should be raised at the time of transactions itself. Stop. Therefore, in my view, the demand raised by the Secretary Mandi Samiti on the ground that the mandi fee has not been paid on the prevalent price was within his jurisdiction. Stop. Present is not the case of any reassessment. Stop. Learned counsel for the petitioners are not able to show that before 30/4/2008 any other demand has been raised. Stop. Therefore, it is a case of original assessment. Stop. In the absence of any machinery being provided in view of the direction given by the division bench of this court, the order passed by the Secretary Mandi Samiti dated 30/4/2008 can be considered only as a provisional assessment. Stop. The case of the petitioners are that they have filed the objection to the forced assessment, while the case of respondents is that no objection has been filed. Stop. However, there is no dispute that no final assessment order has been passed after the order dated 30/4/2008. Stop. In the circumstances, I am of the view that the objection of the petitioners requires to be considered by the Secretary Mandi Samiti, and on consideration of the said objection, the final assessment order to be passed. Stop. In this view of the matter, without going into the controversy whether the petitioners have filed objection or not, the petitioners are directed to file a fresh objection within a period of 1 month, and the Secretary Mandi Samiti is directed to decide the objection and pass the final assessment orders. Stop.